Matter of Oceanview versus Zucker. Counsel?
Thank you, Your Honor. May it please the court, I'm Michael Horelchek of O'Connell and Aronowitz, representing the appellant Oceanview Manor, and I would like to request 3 minutes for rebuttal.
Yes.
The challenge regulations at issue in this case expressly single out a class of persons with disabilities and deny access to housing solely on the basis of that disability. This is the exact sort of invidious discrimination the Fair Housing Act was designed to prohibit. And if these regulations applied to any other protected class, the invalidity would be immediately obvious. There's nothing in the Fair Housing Act that justifies lesser protections.
Yeah, but there is a difference, is there not? Obviously, if the regulations said you can't go above 25% of female patients, that would harm the female patients. But if indeed you have patients who are harmed by too many people with particular needs that cannot be addressed by the facility, there's some benefit to be gained by a cap that is lifted once you get below the 25%. Is there not?
I'd like to address that in two different ways,
Sure.
one as a legal matter and one on the facts
Sure.
in this case.
Sure.
And as a matter of law, you know, the state has argued, and the court below, they held that the under a kind of an exception for benign or beneficial discrimination that purportedly benefits the class of people, that this could be justified. We have argued extensively in our papers that this supposed exception, which is nowhere in the statutory text of the Fair Housing Act, is not legitimate. And I would point specifically to the Supreme Court's decision in the Bostock case, which was a Title VII case about sex discrimination.
But Bostock didn't involve two competing federal statutory mandates, right?
Well, yeah,
The question in Bostock was simply, I think, what did the words in Title VII mean as applied to a particular group?
Yes, and I'll come back to that point also, but the point I was making about Bostock is there's a specific discussion in Bostock where they say when we are looking at whether something is discriminatory, what we care about is the impact it has on a particular individual. Does it treat an individual?
I'm just asking whether Bostock is as on point as you're suggesting, because unlike Bostock, this case concerns both the FHA mandate and the ADA mandate.
Right. So I would respond to that on two different points, both as a factual matter and as a legal matter. And first of all, the courts have said repeatedly, the Supreme Court and other federal courts, that when you have two different federal statutes, that they should be read harmoniously, read not to be in conflict with each other. So if the Fair Housing Act, which expressly prohibits discrimination on the basis of mental illness, that unless there is something in another federal statute that mandates that sort of discrimination, it should not be interpreted to require
What about the integration mandate that follows from Olmstead? And, you know, as the litigation, the related litigation, starting with DAI and then the O'Toole settlement suggest, I think that there's some sense that the percentage in these facilities is relevant to ADA compliance, but maybe you have a different view.
Yes, and I'd like to also address that in two different ways. The first is that as far as I'll start with the federal settlement. Let me start with Olmstead actions have been brought against various types of living arrangements in states all across the country. There was testimony from the state's own expert at this trial that this is the only instance where a state has tried to comply with its Olmstead obligations through direct discrimination against persons with mental illness, where every other state has complied through increasing opportunities for those persons rather than a discriminatory bar on access to certain housing. Here, the O'Toole settlement put in place an in-reach program where people that were already in these adult homes, the targeted adult homes, were offered new opportunities where they could choose, if they so chose, to move out into a different opportunity. So it was expanding options, which was, if you go back to the original Olmstead decision, it was all about choice. The court was very clear that this is about expanding choice, giving options in other settings. But it's not about closing the door on anyone. The regulations we're challenging here bar certain people from access to these homes without providing anything in exchange for that. They're given no new opportunity. Yes.
Assuming you agree that part of the ADA mandate is not to warehouse the mentally ill in these types of facilities. How do you, since you're the one who said the goal here is to harmonize the two federal mandates, how would you harmonize it differently than the way DOJ and DOH did in their agreement?
Well, so what I would say is that the in-reach program that was put in place through the O'Toole settlement, where they are giving these opportunities for people to move out into other the supportive housing units, that we have not challenged that, and we think that's perfectly appropriate. That is something that expands choice. It gives a choice to those persons who are, in these facilities with this concentration of people with mental illness, and is giving them an additional option, an opportunity to move out. And it's the other piece of it that deals with a different population, people who have never been in these facilities and are looking for housing options, and closes a door to them solely because of their mental illness.
But I think the settlement also cites these regulations specifically, does it not? And DOJ, who is tasked with doing significant enforcement, I think not just under the ADA, but also does housing discrimination enforcement, seems to take the view that the regulations are relevant and perhaps integral to compliance with the Olmstead mandate here in the state.
So I would answer that in several different ways. First of all, again, it is only in New York where the Olmstead obligations, where in the context of this O'Toole settlement, where the state has...
Be that as it may, there is that indication, I think.
And so then I would refer back to the factual record in this case, in the extensive fact-finding by the trial court on the issue. And the question is, what benefit is there to this class of people from being excluded, from the door being closed on them when they're not being provided with anything else in return? And again, the question is...
So is that really what is the basis of the claim? If they had the other options, it would be fine to have the regulation in place?
So
as long as they could go elsewhere? It still sounds like discrimination to me.
We agree completely that it is discrimination. However, the state has justified it under the claim that it is actually benefiting this class of people. So if the claim is that these people are being benefited, then you have to ask, is there an actual benefit? If there is no actual benefit, then they can't rely on this supposed beneficial discrimination exception.
Counsel, could you explain for me simply, if possible, how do these regulations work?
Okay.
How do they affect the facility?
So what happens is, if any person, when someone applies for residence at one of these adult homes, the adult home is required to submit that person's identifying information to the State Department of Health.
Regardless of whether they're getting any funding from the state?
Yes,
Okay.
regardless. Any applicant, they have to submit that applicant's identifying information to the Department of Health. It's called the pre-clearance process. The Department of Health then, if the person has no diagnosis of mental illness, they come back and say, you're permitted to admit that person. If they do, they come back and say, this person is prohibited from admission, you have to turn them away. That is plain and simple the way it works.
Again, that doesn't follow state funding or federal funding at all?
No, it's for any... the adult homes in these are heavily regulated by the Department of Health, and as part of the Department of Health regulations that apply to them, any resident, if
But
they...
just to clarify, that's if it's above 25% already
If
in
it
the
is a
facility.
transitional adult
'Cause there's a
home-
cap. It's not that everyone, it's once you've hit that cap, correct?
Right, but...
And it is for the seriously mentally ill, correct?
So I'd like to address that as well, because
Well, on the first part, you agree with me. It's once you've hit the cap, that then you cannot
Right,
accept more
but
people.
at the time when this went into place, there were many of these facilities that were, if the cap is 25%, there are many facilities that are over that. Say they have 40%, 50%, whatever. It serves as an absolute bar to those facilities.
Let me
to
ask, if you
introduce
were
any other-
already at 40%, did it require the facility to then remove people, to send them elsewhere?
It required them to participate in the process to give these people opportunities to get them out of the house. They were not required to evict anyone or to forcibly remove anyone, but they were required to take efforts to facilitate
When they get to
them.
25%,
Yeah.
then is it essentially a one-for-one? So if you want to admit someone, you have to lose someone?
So in
So you
theory,
maintain a 25% ratio?
This gets a little complicated the way it plays out in practice, but in theory, once a home is no longer a transitional adult home, so if they lost their mental health census declined enough to bring them out of that category, then they wouldn't be covered by that, and they would immediately come. But then as soon as they admitted someone, they'd come right back into it and become that. And there's a lot of bureaucratic, things that are involved in being designated as a transitional adult home, new regulatory requirements and things that come on. So this law has kind of an interim effect on facilities that are near the threshold where they have a very, very strong disincentive not to admit people that would put them
So
over
it
the 25%
functions as a
cap.
25, I know it's called 25% census, but it functions at a 25% cap.
In theory, yeah, yes, eventually.
So what standard are you asking us to evaluate this claim under? Why shouldn't we do what the 6th, 9th, and 10th circuits have done?
So first, I would contest that there is a consistent standard that's been applied by the 6th, 9th, and 10th circuits, and we've walked through that in our briefs, that they are not actually applying the same standard. They're applying materially different standards. But we would say the best, the court that most closely does that follows the actual statute is the 10th Circuit's decision in the Bangerter case. But what we would say is the court, you need to give weight to the express preemption provision in the law, which says that if a facility, if a housing provider is prohibited from doing something, the state cannot permit or require them to do that. And if a housing provider cannot turn someone away because they have a protected disability, the state can't then require them to do that. It is right in the law. It's black and white, clear as day. The state cannot require or permit something that is otherwise prohibited.
And if we disagree with you on preemption?
So if you disagree on that, if you adopt something more like the state's view, again, we make the extensive argument that the beneficial discrimination exception that they've relied on has no basis in the statute and is not just plainly illegitimate. But even if you accept that you're going to apply that, the case law that has applied that in other racial contexts, other things like that, has said this is extremely narrow and has to be very carefully applied, and they have expressly rejected any sort of ceiling quota, which is what's at issue here. That's been flatly rejected by the courts as a permissible means of implementing that exception.
Thank you.
All right. Thank you.
Good afternoon, Your Honors. May it please the Court, I'm Gary Malone, representing Respondent, the New York State Department of Health.
Counsel, can
Yes.
I ask you for starters about the standard? So the cases in the federal circuits, I'm not completely persuaded they're on point because they seem to me to involve circumstances where you have an alleged FHA violation, and on the other hand, you have some explanation for the conduct that is arguably protective of the class that's at issue or benign or whatever word we want to use to describe it. But here, by comparison, so those are the zoning cases, right, the SRO single-sex case. Here, instead, we have two different federal statutes, and I think the question maybe is, unlike in those cases, how do we reconcile the two federal statutes? So why are those cases on point? And also, maybe you can tell me what we do about the point that your adversary makes about whether or not the first case and then additionally the others, by resting in part on Weber, which I'm not sure, how strong a footing Weber still stands on, what to make of that.
Okay. Several points, Your Honor. First, with respect to whether there's a benefit here.
Now, I'm asking what the right standard is, not whether there's a benefit, but whether the federal circuit cases are actually on point here, because here instead we have two different federal statutes.
Oh, those federal cases, Your Honor, are definitely on point. When you look at the standard, and counsel is mistaken when he says that there's a split between the 6th, the 9th, and the 10th circuits. They use a slightly different verbiage, but essentially the appellate division got it right when it said, when you boil all those cases down, what they're essentially saying is there a benefit to the protected class?
But none of those
Right.
cases, unless I'm missing something, none of those cases, I believe, involve a additional federal statute. And so maybe the question, I don't know, is not the standard that the federal circuits have laid out in, I think, trying to figure out, is this conduct acceptable even if it appears to violate the FHA for the reasons that you're saying, benefit, et cetera. But instead, what do we do about making sense of the ADA Olmstead mandate and the FHA mandate, and what's the interplay between them?
Okay, that's an excellent question, Your Honor, and the Department of Justice answered that question in its statement of interest. The Department of Justice which enforces the Fair Housing Act, and is one of the agencies, along with the Department of Housing and Urban Development, that enforces the Fair Housing Act. And the Department of Justice is the only agency that enforces the Americans with Disabilities Act. And in fact, the Department of Justice is the promulgator of the
Right.
federal integration mandate. In its statement of interest, the Department of Justice discusses the interplay of those two statutes, and it discusses whether or not there's any conflict. And the Department of Justice is very clear here that there is no conflict, and the Department of Justice, in its statement of interest, cites policy statements that it entered into with Housing and Urban Development.
And they also say, I think this is at 8721 in their statement, they actually argue that this is in fact not discrimination because it rests on a clinical determination. And it seemed to me that that's not an argument that you adopted, and I was curious why.
On the contrary, Your Honor, we do adopt that argument. In our brief, we say that the benefits here are essentially twofold.
I think, though, they're saying we don't even have to get to that inquiry because it's not discrimination that's cognizable under the FHA in any event because it's a clinical determination about whether the facility can provide therapeutically effective care at that above the percentage. But I didn't take you to be advocating that, instead just turning to the question of whether it's permissible.
Well, we think that is accurate. In the brief, we discussed the appellate division decision, which takes the position that the regulations are facially discriminatory, and we talk about how that is supportable. But we do agree, because the regulations here have a therapeutic purpose, it should not even be considered discriminatory at all. And what we- I'm
So
sorry.
where in your brief, maybe you can point me, where in your brief do you argue that it's not discrimination for purposes of the FHA? I might have missed that.
Okay, well, we,
Not that it's permissible, but that it's not even, you don't even have to go through the FHA analysis.
I believe in the very first section of our brief, we say that this isn't discrimination at all, because when you talk about discrimination under the Fair Housing Act, you're talking about discrimination against the protected class. And here we have not a discrimination against the protected class, we have differential treatment that benefits the protected class.
But is that true in all
yes.
cases? I mean, I thought at the Supreme Court they had an example in that opinion, extensive fact-finding of someone or a relative of someone who wanted to get into a facility and was turned away and had to go to Dutchess County or something. Does that benefit that particular person?
Well, that person was turned away from a segregated transitional adult home in which the majority of people
So
had-
it's beneficial to that person, they just don't know it.
Yes, which occasionally does happen, Your Honor. And the person was sent to a different adult home that was not segregated, that was not a transitional adult home, that the Office of Mental Health has decided are not therapeutically helpful to people with serious mental illness.
So even a
And-
person in that position who wants to go to a particular facility using private funds, knocks on the door, they can say, no, I'm sorry, you have a serious mental illness, you can't come in. We have 25% already, thanks.
Yes, because, Your Honor, the Department of Health here has to develop standards for a heavily regulated industry, the adult homes. And when the adult homes are segregated, it's harmful to the people actually in those adult homes that they're not getting to have interactions with people who do not have serious mental illness. That's the whole point of the integration mandate. And Congress has a policy that says it's better for people with serious mental illness or people with mental illness to be able to interact with people in the community. And to the extent that...
And there's a very
Yes.
flexible standard there, right? And I understand there's expertise at the state level in assessing this, but there's much flexibility in that mandate, as you call it. So when we get to a review of what avenue the state has chosen to take, how do we weigh in the potential violation of the FHA, or at least the facial discriminatory effect of the new law?
Okay. Well, there is no violation of the FHA, as the Department of Justice discusses in its statement of interest, Your
I
Honor.
understand the
Yes,
Department of
right.
Justice's position, but I want to know legally your explanation on the law of why I'm thinking of Judge Rakoff's opinion in the Southern District in Sierra, where he's looking at a similar thing, and he's saying least restrictive means, right? And that language comes from different things, but if you're looking at a settlement to comply with a mandate, approaching it as the least restrictive means so you don't run potentially afoul of the FHA seems to make sense to me.
Well, most of the federal courts of appeals that have considered this have not said that you need to adopt the least restrictive means test. They say
understand.
that it should be narrowly tailored, which makes more sense, because you're not essentially asking the government then to prove a negative. And what Olmsted said, Your Honor, is that you should give deference to the considered medical judgments, to the considered professional judgments of state health officials. And Olmsted, in fact, actually said sometimes that means you can't just go along with an individual's choice because you're trying to have broad regulations here. In Olmsted, the court said a state could defend its policies by showing that in the allocation of available resources, immediate relief for certain plaintiffs would be inequitable given the responsibility the state has undertaken for the care and treatment of a large and diverse population.
I think some of the issue we're having here, or I'm having, that is someone goes to get a housing accommodation, they otherwise qualify for this housing, they want to be in this housing, and they are told because of your characteristics, because you have a serious mental illness, you can't come in, we have enough. There's something fundamentally at odds with a fair housing approach in that scenario, isn't there?
No, Your Honor, and the Department of Justice said that with the Fair Housing Act, one of the main goals of it is integration of people with disabilities into the community. And that's being served here by these regulations. Because the federal case, Your Honor,
But what if the
yes.
person could show that that particular facility has a better medical support for my particular condition than the one in Dutchess County? So where's the weighing of more integrated setting with medical need?
Well, first, Your Honor, that's not in the record. There's no record.
It's a
there's nothing-
hypothetical.
Okay, it's hypothetical. In that hypothetical, Your Honor, it would depend upon the circumstances. The Department of Health has not just a waiver provision for people who are previous residents of transitional adult homes, it also has a general waiver provision that it can generally make waivers. So if it really were the case that a person could receive adequate medical care from one transitional adult home and no place else, which is unlikely, but if the person could show that, the person could ask the Department of Health
What if
for a
it
waiver.
was a support situation, which is more similar to what is in the record, I believe, where the family support, which this person believed was critical to their well-being, was in Long Island, let's say, and because of the 25% rule, you're being placed in Dutchess. Could you get a waiver for that?
Just on those circumstances, probably not, Your Honor. But the problem here is that when you're having a heavily regulated industry, such as the adult home industry, and you want to have rules to desegregate facilities, that in federal court, under Judge Garifas, there was a determination that there was warehousing, that there was segregation. And that's why the state then entered into a settlement agreement with the Department of Justice and disability advocates who were arguing that the state needed to do this to prevent warehousing and segregation of people.
On
Can you
that
clarify-
question,
Can you clarify, I'm sorry, can you clarify what happens when a person does go to, or seeks to live in one of these facilities and they're told, I'm sorry, we're at the 25 cap, we can't do that, or however they're told they can't be admitted, what then happens?
Well, the person
I
can...
think they argue that sometimes they can become homeless, so I just want clarity on what happens.
All right. Well, there's no support for that in the record, Your Honor. The officials at the Department of Health and the Office of Mental Health said they've not received any reports that people are having difficulty finding appropriate housing because of the regulations. And there was evidence that there were vacancies in non-transitional adult homes across the state.
So
And-
what
I'm sorry.
efforts were undertaken to make up for the fact that they can no longer go into those transitional homes? Are there additional settings that are created so that they could have those options?
Certainly, Your Honor. In fact, in the record, we show that there's been substantial resources, many millions of dollars spent each year to increase the availability of supported housing. And this,
Can you tell us where in the record specifically that is? It's a big record.
yes, certainly, Your Honor.
And while you're looking, one other record question I have
Yes.
for you. You've made the argument a couple of times, and you make the argument in your brief that the cap is necessary to further compliance with the Olmsted mandate. And so I think that Mr. Martone's testimony addresses that. If there's other evidence in the record that supports the nexus between the regulation and that goal, maybe you could point me to it.
Okay. And, well, with respect to the, in the record, we discussed this at pages 15 to 16 of our brief, that there's been substantial resources devoted to supported housing. And there's quite a few record sites. It's at the top of page 16 of our brief.
So would you feel comfortable making the representation that in this record, if we look in the right place, that there are sufficient services available for anyone who's turned away from a transitional adult home? Somewhere, there's a place for them to go.
Yes, Your Honor.
Okay, can we get back to my question? So my question was, what happens when someone shows up, they can't be admitted into that home? What happens? Are there staff at the home who help them find another placement? Or do they call some DOH representative? What happens?
It really depends where the person is.
Okay.
In the system, if the person's in the system at all. The Office of Mental Health
Yes.
has substantial staff dealing with people with mental health issues that can help them. And if
And then
there's-
they would refer them? Is that what you're saying? They would refer
They
them?
can do that, yes.
To an appropriate, what DOH deems to be, or Office of Mental Health deems to be an appropriate living situation?
That can happen,
So
yes.
they would not be referred to a shelter or told, we can't find anything for you tonight, that kind of thing?
It depends upon a hypothetical whether or not when they called, but there's nothing in the record indicating that that happens, as I indicated.
Chief, can I ask one more? What is your best argument for why the state shouldn't be held to a least restrictive standard here? I mean, I know you're saying narrowly tailored. I don't really know how that's defined. To me, it seems like if you have a reason for it and it's pretty rational, then it's good enough. But why shouldn't the state be held to a standard like Sierra?
Well, Your Honor, we would say that the state actually does meet the Sierra standard. But the problem with the Sierra standard, Your Honor, is it's too restrictive because it essentially requires then the state to prove a negative. And we showed at the trial that there's really no alternative that would serve these goals in a more narrow way. The trial court said, well, why don't you have like individualized assessments and do this on an individual by individual basis. But we, as a Department of Health official testified, if you do that, then you're not going to reduce the number of people with serious mental illness in these facilities, because then essentially it's no standard at all. And with respect to Your Honor's question regarding the 25% cap, we'll point out that other federal policies, such as the Frank Melville program, which we cite in our brief, has a 25% cap, saying that in order to get federal funding, you have to have no more than 25%.
I know your light's on, but if I could just ask one last question.
Yes.
I'm just curious if the record happens to reflect. I think generally the Attorney General's office represents the commissioner. Is there anything in the record about why that's not so here?
I don't think there's anything in the record on that, Your Honor.
Okay, thanks.
Okay. And just very quickly, Your Honor, with respect to the 25% cap, I'll also point out that the Department of Justice and Disability Advocates, when they originally brought the case against the state, claimed that facilities that had more than 25% were not in compliance with the federal Olmsted mandate.
Thank you.
Thank you, Your Honor.
In my limited time, I'd like to try and address a few different things. First and most importantly, the facts matter. This was a trial with 18 days of testimony and an 81-page opinion with detailed and extensive fact-finding. And among other things, the trial court found that the state could show no benefit to any person who was excluded from admission. They could not point to a single person excluded from admission who then ended up in what the state would consider to be a better environment. And on the contrary, there was direct evidence of harm to at least some persons who were excluded. Now, the question was asked, what happens to someone who is excluded? When someone comes, they apply for admission, and they're excluded because of their mental illness. The state's own representatives testified at trial, nothing happens. The state does nothing. They do not track these people. They do not offer any services to them. They provide nothing to those people. They are turned away. That is what happens from the state's perspective. The argument was made that there's no evidence in the record that some people end up homeless as a result of this. That is not true. In the record, there was testimony from a discharge facilitator from a nursing home who testified that when someone is getting rehabilitation and they are ineligible for placement in a assisted living bed in a transitional adult home due to their mental illness, that they will often be discharged back to a homeless shelter. So some people, the alternative is between a transitional adult home and a homeless shelter, and that is in the record. I'd also like the court not to lose sight of the assisted living programs, the ALP beds, that represent the primary population served by most of these transitional adult homes, including Oceanview Manor. And these are people who need a nursing home level of care. Under the statute, they have to be eligible for a nursing home level of care in order to be in these ALP beds, which are the majority of the residents of most of these homes. These are people who have very limited options, and if they are not allowed into an adult home, it may be that a nursing home is their only viable option. Which is a more restrictive setting, a setting where they can't come and go as they please, where they're in a locked down facility. So then I'd like to
Did the appellate division make different factual determinations than the trial court?
The appellate division asserted multiple times it referred to the benefit to these individuals of being in smaller, more integrated settings. But the trial court said there's no evidence that anyone is actually...
What about the appellate division's summary of the trial experts?
What?
The trial experts and its own reading, the appellate division's own conclusions based on that testimony.
It said
is that a different fact finding?
Well, it said that the experts... Well, they characterized the experts as saying that people were better off in these smaller, more integrated settings. But the important findings are that people are not ending up in those smaller, more integrated settings. The people are ending in homeless shelters. They're ending up in nursing homes. There's no effort to get these people who are excluded at the front door to get these people into those supported housing environments. So any claim that benefit justifies this regulation is undone by the fact that benefit doesn't exist, and the trial court made extensive findings that the state had failed to put on any evidence.
Is that a challenge to the propriety, the lawfulness of the regulation, or the implementation may miss a step here and there, and individuals have other administrative and perhaps judicial recourse to address when the administration fails?
There is no other means of recourse. The regulation flatly requires that these people be excluded if they meet those criteria.
No, I'm not talking about that part. I'm talking about your argument that they're excluded and then they're left hanging. They have no place to go. And he says that's not what happens. You say that is what happens. So my question is that really, excuse me, is that really about the regulation or about the implementation of the regulation, which can be addressed through some other kind of individual-based challenge?
If the state had implemented some other program where they were somehow, tracking these people or providing, some other opportunity so that the people were not being turned away, then maybe there'd be a different set of facts that would have affected, whether there's any benefit.
Well, it's not about not being turned away. My question was not about that. And it was not about what you had said related to that. My question is, when you hit the cap in one of these facilities and they cannot admit them, their argument is, but then DOH and the Office of Mental Health addresses that by ensuring that they have an appropriate placement.
I don't know where they're getting
that's not true.
That's not in the record, and it's not true as a matter of facts on the ground. That somehow people, when a facility is over 25%, that people who want to get admitted there are getting some other offerings.
Is there anything in the record that shows the fraction of beds that are in homes that are not subject to the 25% cap because they are under the 80-bed threshold?
I do not know that there's anything in the trial record that directly goes to that. There was some discussion, I know, of the geographic distribution, and most of the transitional homes are concentrated in New York City, and many of the non-transitional are in upstate and other areas of the state, but I don't know that there's any statistics that would go to that question in the record.
Thank you.
Thank you.